Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 117 of the podcast. Thank you for listening, supporting me for the last 2 years. Truly appreciate it. And I hope the information that I provide to you is helpful to you. So today I'm going to talk about a different subject. And it's coming very often as well. So I'll give you an example that happened a few years ago. This client is a restaurant owner, and it's a restaurant and it's very busy. And unfortunately, in some cases, he did not keep the proper payroll records. And he also, as a bonus to some of the employees, he also paid in cash. And, did not keep track of that cash, did not report it. And did not keep track of the overtime. It's a very small business, had, a couple of employees, and then some of them also were classified as 1099 employees. As you and I know, we listened to me before, that does not exist. They were just considered independent contractors, not employees, even though they're required to show up to work certain hours. They were, provided uniforms. They were required to, directed work. They were employees. They were not independent contractors. So at one point, he terminated an employee that was with him for at least 5 years. And the employee was like a front desk type worker, kind of like a hostess. But also she worked also as a server as well. It's a small deli. And so the employee was terminated, and the employee felt that she was discriminated against because she had apparently some type of illness. And also she is alleging that she was not paid overtime, and she was not paid for the hours that she worked in some cases. So the client received a lawsuit in federal court for unpaid wages, unpaid overtime. And that's when the client called me. So when I looked at that, I said, okay, so what happened here? And the client explained it, which is kind of explained to you. We treat her like family. Which is not very uncommon. We're dealing in a small business. People get to know each other very, very well. And there's some formalities that sometimes are missed, or they're not missed, they're kind of ignored, or they're just not followed. And it's not ill-intended in any way. It's simply that the formalities just are not followed, which is not a good idea. The client handled his own payroll. Didn't have a payroll company handling it for him. So, which created another set of issues as well. And if I give you one tip today, several that I will give you today, is that if you have employees and you're paying payroll, like W-2 employees, I strongly recommend getting a payroll company. Don't try to do a payroll yourself. You can do it. I mean, QuickBooks, I believe you can do it with QuickBooks. There are many software programs that will help you do that payroll yourself. But for the cost that the payroll companies charge per payroll, to the benefit that you receive in reference to having a secret portion of that administrative task be delegated, it is worth getting a payroll company. And I'll give you an example. When you have a payroll company, they withhold the payroll taxes for you. The ones that you have to pay on behalf of the employee, but also the ones the employee has to pay. They pay those quarterly to the IRS. They file your 940 reports, your quarterly payroll tax returns to the IRS. They file them for you. It comes from an accounting firm, from a payroll company. They sign them for you. You give them power of attorney for them to sign it. They handle that for you. They also file the R6 reports in Florida, which are the state payroll tax returns. They withhold the unemployment insurance. They withhold any payroll taxes you got to pay to the state. Okay, so all that administrative tasks, okay, is delegated and handled by a professional payroll company, and there are many of them out there. Not going to promote any of them, but you can Google payroll companies, and many of them will show up. Okay, so that in and of itself will make life a lot easier for you. There's also one more benefit of having a payroll company. If you have more than 4 employees in Florida, you need to have something called workers' compensation insurance. It's required by state law. Your workers' comp carrier every year is going to request an audit of your payroll. It's going to ask you for all your tax returns, state and federal. It's going to ask you for the list of employees, the job descriptions, and they provide that audit. And if you do not provide that information on time, you can get fined by the workers' comp carrier. So by having that already with a payroll company, all you got to do is go to your online account, your platform, you download those reports, you send them to the workers' comp carrier. They're done. Simple. So I think that from a pure administrative perspective, and something you can delegate for what it costs. I think it's maybe, I'm just giving an example, $100 a payroll to handle that. Might even be less. You are getting yourself a tremendous amount of work to somebody else that is going to be done professionally done. It's going to be done well, and something less you have to worry about. But we're going back to our example that we had here. So the client said, no, we paid her. We kept track of all the hours, and he gave me kind of a spreadsheet how they kept track of the hours. This is how much we paid. And, they handle some type of internal payroll. Some of the hours were not kept properly, which, it created an issue. Excuse me. So when I asked the question, I said, do you have payroll reports? Do you have, give me the tax returns you filed with the state. Give me the tax returns you filed with the federal government for the payroll taxes. I know we don't have them. Some of them were missed, which complicated things even more. We do that at the end of the year. No, you're supposed to do every quarter. Okay. So there were problems. They were compounded and compounded and compounded, which could have been prevented. Let's get a payroll company to handle it. It's worth it. Also, a tip. This is not a requirement, but this is a pro tip. Have a payroll account separate for payroll. It's just anything that goes into payroll benefits. If you keep a separate payroll account and you fund it every week when you pay your payroll every 2 weeks, if you need to have an audit of that account, everything is in that account. It's not mixed with anything else. The only thing that's going to pay it out of that account is going to be payroll. It's not any different from any other account. You go to the bank and you open an account, whatever bank you have, and you designate it as payroll. That's all you have to do. It's not a special account that you create for payroll. Simply, that's the way payroll is going to be handled. Then you fund it from your operations account into payroll. That's paid. So in the case you need to look at something, you can run that report, you can run the statement of the payroll account, and everything will match. So it's a very simple fix and a tip that I'd like to share with you. Now, so went back to the client and said, well, we have a problem. The way the law works, especially Fair Labor Standards Act and also Florida statute as well, okay, if you don't have the accurate payroll records, okay, it is assumed that the employee's assertions are correct. This is a pro-employee statute. It is designed to protect the employee. if you don't have the hours that they worked every week and they're an employee and they're non-exempt, meaning that they're entitled to overtime, they say, I didn't get paid overtime and I work extra hours, they're going to believe the employee because you don't have records to show that in this particular week, in this particular period, that employee did not work extra over 40 hours a week to be entitled to overtime. Whether the employee received lunch breaks or not, you need to keep track of that. What breaks the employee took. How do you keep track of that information is essential to defend these types of lawsuits. And another thing is that for the employee, it doesn't cost a lot of money to file these type of lawsuits because the statute provides attorney's fees, and those are negotiated separately. So there are law firms that are dedicated exclusively to take on cases on a contingency basis to help employees collect unpaid wages. Let me repeat. There are law firms that are dedicated exclusively on a contingency basis to help employees collect from former employers unpaid wages and overtime. So the cost to you as the employer, as the business owner, excuse me a second. The cost to you as an employer, as a business owner, is that you will have to retain counsel to represent you defending these lawsuits. You will have to, and it's going to cost you quite a bit of money to do that. The employee is already disgruntled because either you fired the employee or you laid him off, whatever the case may be. So people are going to the attorneys who specialize on labor law and specialize on wage and hour issues or unpaid wages litigation, that they go to those law firms. They're not going there because they're happy. They're going there because they're unhappy with you to start with, and number two, they believe that they were not paid properly. So that employee is not going to be on your side. The law firm is not going to be on your side. The law firm's motivation is to collect those fees, those unpaid wages from you, but also the way they make their living is by collecting attorney's fees from you. Now, it's important to note here that unlike personal injury, and I'm going a little bit more on a rabbit hole here, that you have these cases you see on TV, no recovery, no fee. The difference here in those type of injury type of law firms, they might be suing an insurance company that that has coverage for the accident in this case. I'm just give you that example. But the fees are based on a percentage of the global amount that they collect. It could be between 30 to 40%. I'm just giving you that as an example. In this case, the way the statute works is that the attorney's fees are separate. So they're not going to collect money for the unpaid, the money that you might owe the employee. Their fee's not going to come from that as a percentage, from that amount as a percentage. The fee's separate. So I'll give you an example. Say they're claiming you owe, say, $5,000 for attorney's fees and overtime. So, and you go through, say 6 months of litigation. And at the end, you decide to settle the case. You decide to, you know what, I'll pay the $5,000. I'm done. Okay? That law firm could have generated about $25,000 worth of work. So you're not going to settle the case without paying the law firm as well. Okay, that's separate. So when you look at any type of litigation that involves overtime or involves, unpaid wages, you have to keep in mind that it's not just the amount that is allegedly owed to the employee, but it's also attorney's fee bill that is coming right after. And in some cases, you have court-approved settlements. Had a case a few years ago in which a similar type of claim was made, and the case was settled. We actually, you remember, had to go to federal court. Before COVID, that we actually went to the courthouse and did the mediations. And this was to the magistrate, and the case was resolved. However, the settlement had to be read into the record. It was a court-approved settlement, and then the portion of attorney's fees, which was paid separately, had to be approved by the court as well. And the reason for that is that the court wants to make sure the employee is taken care of, that there's not a situation that the employees, when the wages that he or she is owed, but also that the fees don't come from that pot, if you will, that the fees are paid separately from the employer to the law firm. So if you're in a situation that you get a demand letter from a law firm claiming that you may owe overtime or overtime wages or unpaid wages to a former employee, my recommendation, as you have listened to me before, is to call legal counsel as soon as possible. Don't call the law firm unless you're asking for an extension that you got served. You have like 2 days to file a response. The only reason you call them and say, I just got this, I need more time to respond, I'm going to get a lawyer. That's it, nothing else. Don't start sending documents. Don't start sending emails. I don't know what's going on here. Here are my payroll records. Check them out. I don't know what the employees. It happens, okay? And when somebody panics, people, unfortunately, sometimes make the wrong decisions. But if you receive a demand letter, which at the demand letter stage is actually it's good to get a resolve at that stage before a lawsuit is filed. Let me explain that. In many cases, when an employee goes, a former employee goes to a law firm and the law firm decides to accept the case, they feel that is a viable case to them to pursue for whatever reason, then usually you will get a demand letter first. You will get a letter explaining the allegations that the employee is alleging that the employee worked for 2 years or more, or whatever the case may be. And during this period to this period, the employee was not paid overtime or was not paid the proper wages, was made work without taking any lunch breaks, so whatever the case may be, and that they're entitled to collect unpaid wages from you. When you receive that letter, do not ignore that letter. Immediately call an attorney, because that letter also comes with a time period. The letter will tell you, you don't respond to us within 10 days, we will initiate legal action against you, et cetera, et cetera. Okay? So the first thing you got to do is call an attorney as soon as possible and retain counsel to communicate with that law firm about the case to see if the matter can be resolved at that letter stage versus the litigation stage. If it gets resolved at the letter stage, it's a lot less expensive than the lawsuit stage, litigation stage, for obvious reasons. They have sent a letter, they have analyzed the case, you're having conversations, you may have exchanged documents in a good faith basis to try to prove the fact that, hey, you do not owe overtimes to this individual. So you might engage in settlement communications right from the very beginning versus litigating. So oftentimes people ignore the letters, and then unfortunately then you have to follow with the lawsuit because there are no other choices. The attorney doesn't have any other choice. If you receive a letter, demand letter, claiming that you owe unpaid wages to an employee and you ignore it, the attorney has two options: not do anything or file the lawsuit, because it's the only way it can compel you to respond. So don't ignore the letter. Immediately get legal counsel. And if you need more time before you respond to the letter, you can always email the attorney, said, I'm in the process of getting counsel. I need more time to respond to this. An acknowledgement, and that's it. And then once you retain an attorney, the attorney will take it from there, sending a letter of representation to that other attorney. And then the communication between attorneys will begin. If it goes to the lawsuit stage, then there are a lot of requirements that we have to do, especially in federal court, that are really more behind the scenes. We got to do initial disclosures. We need to do a lot of different reports to the courthouse, to the court, with respect to the case. And at that point, that opportunity to settle pre-litigation stage is gone because you're already in litigation. So the sooner you can resolve this case, the better. Now, another thing I want to talk to you about is misclassification of employees, which can lead to wage and hour type of litigation, unpaid wages litigation. You have to make sure that if somebody's working for you, you classify that employee properly. Oftentimes, a business owner, in order to save some money, brings people in what is referred to as a 1099 employee quotes. That does not exist. The person is a W-2 employee or an independent contractor. It cannot be both. You know, I believe I go over that in my book as well, but I've gone through various examples of the difference between independent contractors and employees. But also use your common sense. If you have somebody coming to your office or to your place of business every day, you are setting hours for that employee. You are providing tools and equipment. You're setting policies. You're setting uniforms. You can fire the employee. You give a direction. That person is an employee. It's not an independent contractor. If the person cannot leave the workspace anytime they want to, and come and go as they please, and have also other interests or other clients that the person works with, that person is not an independent contractor. And I'll give you an example. A graphic designer that, say you hire a graphic designer for your company, you're going to provide the computer, you're going to provide the software. The person is working even part-time, but it can be full-time, say 8:30 to 5 every day, Monday through Friday, and is creating marketing material for you, social media posts for you. That person is an employee. The person might have a company before, but that person is an employee. So you got to pay through payroll. If you hire a graphic designer, the same graphic designer, this graphic designer happens to have her own company, and she has her own clients that she handles. She comes to your office once a week to meet with you, or maybe you meet via Zoom. You don't set her hours. You don't provide equipment. You don't provide software. You pay through her company. That graphic designer is an independent contractor because you really don't provide direct supervision. It's really more of a client-vendor relationship, and she also gets paid by the work that is done for you, not by the hours that she's actually working for you. And you get an invoice, and so really you have more of an arm's length relationship versus an employer-employee relationship. And I see that often in small businesses, people try to shortchange or try to shortcut, if you will, the system by creating this quasi-employee independent contractor classification in a way to avoid paying payroll taxes to save a few dollars. Excuse me. It is not worth it. It's not worth it to do that for a number of reasons. We talked about that before. The relationship ends sour. You could be a potential target for a wage and hour lawsuit, or the employee feels that, you know what, I was not getting paid what the overtime that I was asked that I should be paid. You can be in the receiving end of those type of lawsuits, and you're talking about tens of thousands of dollars to defend. Because you got to pay your lawyer. You also have to pay her lawyer, and then you got to pay the unpaid wages. You're paying 3 times here. So, yeah, in that case, it's just not worth it. You know, if you're going to have independent contractors, true independent contractors, I do recommend having an independent contractor agreement in place that is very clear and specific about the duties, what the relationship is, and there's no doubt that that individual is an independent contractor. For employees, I do recommend also an employment agreement. And if you're also a company that has a number of employees, then I would recommend getting an employee handbook as well. That's a different topic altogether that we can explore at a different time, but I wanted to share with you that. It's, you know, having the classification is important. Another point is here. Say you want to sell your company. At some point, your company is going to close, or you're going to sell it. I mean, you know, nobody lives forever. So, say you want to sell your company, and one of the items in due diligence that you will be asked for, I want a list of all the employees that work for you and a copy of your payroll, you know, your payroll taxes and your payroll reports. And if you say, well, they're all 1099s, they're all 1099 employees, and then you find out that it really should have been employees versus independent contractors, or this kind of morphed classification of in between, you might be a prospective buyer of the business may say, you know what, I'm not going to take the chance. You know, it's just not worth it to me to take over this business and then possibly be in the receiving end of a lawsuit for unpaid wages because you didn't pay your employees the right way for the last 5 years. So you might be in a situation that you're devaluing your business in such a way by not paying employees properly and through the correct channels. So that's also another reason that I say do not take that shortcut, do it the right way, do it through payroll. And one last point, and I get that question often, is that what if I have an LLC or a company, would that protect me? The answer is no. You personally could be held responsible for unpaid wages. You're not going to be protected by the corporate veil on this one. You're dealing with the federal government and state government. So withholding, not paying the federal government for payroll taxes, you can end up personally liable for them. So it is not worth it to do that. That's why it is important. It's better to have a payroll company which automatically withhold that for you. They keep it on their escrow account and they pay those for you on a quarterly basis. You don't even have to see it. And also having a separate payroll account is not required, but it's highly advisable. So that way the payroll, everything is gone through a payroll account and you don't have to combine it with any other bills. And there's not the temptation of using those payroll funds or those tax funds to pay expenses. That's why, business owners with a cash crunch, sometimes that happens. Okay. This is good for today. I do appreciate listening to me this morning, afternoon, or evening, whenever you listen to your show. This episode 117 of the Business SOS podcast. If you want to, you have any questions about any topics that I discussed today, my email is rich@richsierra.com. If you want to check out the legal services that we offer, my website is floridasmallbusinesslegalcenter.com. Our phone number is 866-842-5202. We're in Facebook and Instagram at FSB Legal. If you would like to see this podcast through our YouTube channel, we're youtube.com/@RichardSierra. Remember my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.